start, and then it,
Okay, so good afternoon. Today is, as everybody knows, July 28th. We are, of course, the Board on Professional Responsibility, and we're here in the matter of Christopher Libertelli. This is board docket number 20-BD-50 and disciplinary docket 2019 D72. I guess one housekeeping thing before we have folks identify themselves for the record. Mr. Coburn, I understand there are a couple of folks from your team who are on the Zoom. If you could make sure folks have their video off, just so the number of squares is limited. Mr. Libertelli, you should feel free to have your video on or off, whatever you want. You've got special status as the respondent. Or folks are welcome to watch it on our YouTube channel, whatever makes them happy. With that, Ms. Porter, Mr. Coburn, good to see you again. Could you identify yourselves for the record? Why don't we start with Disciplinary Counsel?
Good afternoon, Julia Porter on behalf of Disciplinary Counsel.
Thanks. Mr. Coburn?
And good afternoon, Mr. Chair. This is Barry Coburn on behalf of the respondent who's present. And as you noted, a number of my colleagues are logged on as well.
Great. Thank you. Mr. Libertelli, good to see you. Thank you for being here. Okay, a couple of things. So first, the record should reflect that Sally Blumenthal, who's one of our public members, is recused from this case, so she'll not be participating in it. Also, Elisa Preheim is one of our attorney members. She's not here today. Mr. Coburn, under our rules, she's allowed to participate in the decision if she listens to the oral argument. My understanding is that you've already agreed to that. And you're nodding, so
we have.
Great, thanks. Okay, so I assume Mr. Coburn's going first.
Happy to.
Exceptions, great. You get 20 minutes. How much time would you like for rebuttal?
If I could reserve 5 for rebuttal, I'd be very grateful.
Great. One last housekeeping thing. I know you both argued in front of the board during the pandemic, but obviously we're on Zoom. Audio and Zoom can be tricky. It's hard to get in if somebody else is talking. We'll raise our hands if we've got a question. If somebody's had their hand up for a while and can't get in, I'll try to interrupt. But if you guys could help while you're arguing and keep an eye out for board members who have their hands up. And also, if you're not talking, I would be grateful if you could mute yourself. With that, Mr. Coburn, whenever you're ready.
Thank you so much, Mr. Chair and members of the board. Very grateful for the opportunity to appear here today on behalf of Mr. Libertelli. I'll start by acknowledging a couple of things, if I may. First, I acknowledge and express our gratitude to the hearing committee number 12, for really an extraordinarily comprehensive and extraordinarily well-written report, which I think is going to be very useful to the board's analysis. And there's certainly no issue about the exceptional level of diligence that the hearing committee brought to bear in this matter. So I want to say thank you to them in this proceeding. Second, the underlying conduct in this matter, by its very nature, is disturbing. I was rereading, as I was getting ready for this argument, Judge Schwelb's opinion, I believe, in the Marshall case, in which he talks about obloquy and shame and things like that when you're referring to a pattern of flagrant dishonesty. And I think the word flagrant is applicable here. We have no dispute with disciplinary counsel's application of it to this case. There's a very disturbing and upsetting pattern of dishonest conduct. It's not just one off-the-cuff lie. It required the creation of particular documents that were fraudulent, and we acknowledge all of that. And Mr. Libertelli openly, I think, acknowledged it during the course of the hearing. So this conduct is disturbing by its very nature, and there can be no doubt of it. And I don't mean anything that we said in any of our written submissions or here to minimize the nature of this conduct in any way. It's something that no lawyer should ever undertake. Mr. Libertelli knows that. And standing alone, were it not accompanied by the substance addiction information that exists in this case, I don't think there's any serious doubt, despite the fact that it's not client related, despite the fact that it doesn't go to the representation of a client or the active representation of a client in the forum where the dishonesty occurred. I think there's very little doubt that the conduct would be disbarable despite all that. And so we're really not taking issue with disciplinary counsel or with the hearing committee with respect to those issues. The focus here from our standpoint is on the substance abuse disorder, or disorders more properly stated. We acknowledge that there are a number of cases, in most particularly we're focused on Kersey and Marshall, that have explored these issues, and the Marshall case carves out a very sharply delineated exception with respect to the use of illegal substances such as cocaine. And that's where the principal focus is for us. First, we think we're substantially different from Marshall in that we don't have someone who just went out and bought cocaine for recreational purposes.
Mr. Coburn,
Yes.
let me interrupt you.
Certainly.
Although your comments has gotten us to a good point here.
Thank you.
Before you even get us to Marshall and whether Marshall was rightly decided or whether it should be revisited or ruled, to get there, wouldn't we have to reject the hearing committee's finding that although Mr. Liberatelli has the disability, substance abuse disorder, it did not substantially affect the misconduct at issue here? In other words, we'd have to find that that was an erroneous finding, not substantially supported by the record, in order to even get to a question about Marshall. Is that right or wrong?
Oh, I think you're right. And I actually put that under kind of the overall label of causation. Causation is a very broad term under any circumstances. And here it encompasses a couple of different things, at least two areas of causation that I think merit focus, and both of which are addressed in the hearing committee report, as Ms. Sargent, you correctly point out. First, or maybe this is the right way to sort of analytically to approach it this way, there's the line of causation between the opioid use disorder and the use of cocaine, or maybe I should say the opioid use disorder and the cocaine use disorder, which I think the committee acknowledges existed here. So that's one line of causation. And the other, perhaps more substantial line of causation is between the substance abuse writ large, that's all the substances that are at issue here, and like you pointed out, the misconduct itself. And I think the hearing committee has doubts with respect to both of those things. The link, but in other words, whether or not the opioid use disorder led to, if that's the right way to put the causation issue, the cocaine use disorder, and then also with respect to whether or not that line of causation of overall use of substances is a substantial contributing factor, if I'm saying that correctly, or a but-for cause of the underlying misconduct. And both of those are subject to question, or maybe I should say they've been decided largely against us by the hearing committee. And so I think you're right that we have to take issue and do seek to take issue with those conclusions. I would say, however, that, parsing the hearing committee's, like I said, extraordinarily comprehensive and very well written report, which I think is like 170 something pages, certainly the longest one I've ever encountered. There are quite a lot of things in that report and recommendation that support our position with respect to both of those issues. It's the overall conclusion that doesn't.
So, Mr. Coburn, a couple of things. First is, I don't think we have to use this phrase but for, because the actual language is substantially affected. So I think you have an easier standard than but for. But, in your brief, you did quote at length from some of the expert testimony, especially on this issue of judgment, effect on judgment. But I mean, take your best shot at persuading me that the hearing committee's interpretation of that expert testimony shouldn't be deferred to as reasonable and substantially supported by the record.
I appreciate No, I didn't mean to interrupt, but I appreciate that opportunity. And that, I actually had my outline focused exactly on that point. I had a feeling that was going to be what I would spend most of my time talking about here. So with respect to sort of strand one, you know, the link between opioid use disorder and cocaine, the hearing committee expresses a lot of doubt about that, whether that link was proven by the evidence. And my submission to the board is that there are basically two sources of evidence with respect to that link. And they both, I think, come from Dr. Richard Ratner. So there's Dr. Ratner's testimony, and I have it teed up here, but I'm not going to waste anybody's time by, you know, reading it into the record. But it is at transcript 941 to 942, where he says, and I think this is quoted in our opening brief. It says, so he says, that's what happens. In other words, the link between these two substances, and that's what happened to Chris, quote unquote. And he says essentially the same thing in his report, which the hearing committee really doesn't detain itself much with the written report. But I think the written report is important. I believe we appended it as an exhibit to our opening brief. And he is pretty specific with respect to that in terms of, you know, like essentially, to put it probably improperly, colloquially, you know, opioid use is a downer, or sort of a soporific, if you will. And so it's not atypical or not uncommon for someone like Mr. Libertelli then to try to offset that effect with a substance like cocaine. And he specifically finds that that's what Mr. Libertelli did. I don't think there is contrary evidence or any significant contrary evidence in the record contradicting Dr. Ratner on that point. It's resisted by the hearing committee. I mean, the hearing committee sort of, I mean, they recognize that this testimony, not so much the report, but the testimony exists. They express some skepticism about it, but I must confess to the board that I don't know why, because I don't think Dr. Sugarman contradicts it, if I remember correctly, or Mr. Labby, or the other testimony that excuse me, disciplinary council elicited. I think his conclusion is pretty well irrefutable.
So,
on
Mr.
that point,
Coburn,
and
can
it
I
stands-
ask you a little bit
Please.
about that?
Yeah,
So,
please.
So as I read it, I understand that an individual who might be on an opioid, which is a downer, might need a stimulant. And I do read Dr. Ratner as saying that that's what was happening here. And to be honest, it's not the first time the board has heard that in cases. Is there a clearer link, and maybe I just missed it, so I'm happy to get a record site from you and look at it, that says that it's not just the use, but that it actually then becomes a disorder, the use disorder? Because in the other case that we're familiar with, the cocaine use in that particular case didn't result in cocaine use disorder. It was used as a stimulant to counteract alcohol. And when the alcohol, when they reached sobriety, the cocaine use stopped as well. Here, the cocaine use didn't stop after the opioids stopped. And so I'm just wondering, did Dr. Ratner or another doctor speak more directly to the fact that there is this link between the two disorders as opposed to just use without a disorder?
I'm pretty certain, first of all, I appreciate that question very much, Ms. Pittman, and I'm pretty certain that the answer to that question is that the hearing committee, and forgive me if I'm misremembering this, but I'm pretty sure the hearing committee actually makes a factual finding of cocaine use disorder. I think there's a paragraph or a couple of paragraphs in which they specifically.
Oh, I agree with you. They found that there is a disorder. I'm just trying to see, is there a connection that the opioid use disorder is the cause of the cocaine use disorder, as opposed to he just has two independent disorders?
I don't think there's nothing that I know of in the record, and I'm probably overlooking something, which will be to my everlasting regret, but I don't think there's anything in the record other than what I cited from Dr. Ratner to that effect. My point basically is I don't think there's anything contradicting him, and I believe Mr. Walker has his hand up. I think you're on mute.
Hi, can we skip just a minute to the rehabilitation part of it?
I think
Well,
Mary
that-
Bob was going
yeah.
to ask a question and is just having trouble unmuting.
I've unmuted, and I wanted to make sure, thank you, Mr. Coburn, for your argument so far, but I did want to get to the point that Ms. Larkin just mentioned. What is the evidence in the record? What is the clear and convincing evidence in the record that your client has been substantially rehabilitated with respect to the disorders that you are arguing he manifests? What's the evidence of rehabilitation, substantial rehabilitation?
My understanding, and here I am referring to finding of fact 249 from the hearing committee. They say, we do not have any reason to believe that Mr. Libertelli has taken non-therapeutic opioids since January 7th, 2018. And he's being drug tested. And there's language from the hearing committee in which they express some concern about the sufficiency of the drug testing because Mr. Libertelli arranges it and, kind of has a role in terms of its timing and so on. I understand those concerns, particularly given the testimony in the record, much earlier in time, of course, that he obtained this item known as a Whizzinator and so on. So there's certainly reason for concern, but with respect to this issue, with respect to the cessation of his cocaine use, which they find in that paragraph, that particular finding of fact, I don't think there's any reason to doubt that. I just don't think there's I guess my overall point here, Mr. Walker, is we're talking about substance abuse, disorder / addiction. So anyone, right, and I'm sure that this probably encompasses a number of us who have been involved in one capacity or another with addictive behavior or addicted criminal defendants or that sort of thing. No one would rationally approach that phenomenon with anything other than queasiness. Is any addiction ever really cured? As someone who's been, has overcome their alcohol addiction for 20 years, are they really cured? I think what you learn basically in narcotics.
Mr. Colbert, here again, you're making it harder on yourself than you would need to be, although query whether your record supports you either way. But here again, the factor is substantially rehabilitated. So that means you could go into a rehabilitation program, successfully completed, and a year later come back, maybe a year and a half, you have a relapse. But a year, I think that would be a lot of evidence towards substantially rehabilitated.
I strongly agree, Ms. Sargent, and I'm grateful for the comment that you just made. And I think, the fact that all the evidence I know of in this record supports the proposition found in this particular finding of fact 249 that he's been off opioids since January 7th, 2018. And they also find in 251. So this is just two findings of fact. Hence, they find that we do not know that Mr. Libertelli, I think I'm quoting here, has used cocaine since the end of 2020. So I believe that fits squarely within the rubric that Ms. Sargent just referred to. There simply is no evidence that either of those conclusions is wrong, that he stopped using opioids in early 2018 or that he stopped using cocaine at the end of 2020. And incontestably, this is a struggle. It's probably a struggle he'll be waging for the rest of his life. And it has been a struggle up to this point, but given the absolute, what I understand to be the absence of evidence contradicting those conclusions, I guess my question for the board is, how could that not fall within the rubric that Ms. Sargent just referred to? How could that not be substantial?
But
So hang on, I think
let me
Ms.
try to
Larkin has
answer
a-
that.
Yeah,
So
Ms.
it
Larkin
might
has
be
a
clear and
point.
convincing.
Yeah, let me try to ask that question, because as I look at it, and then I look at his record of altering information, of lying on forms. What makes me believe that behavior hasn't contributed to him submitting to other people that he has substantially rehabilitated? Because we went there before, but it wasn't true.
I think, Ms. Larkin, that concern that you just expressed is sort of the central animating factor in the hearing committee report. And I cannot rationally, certainly not as an officer of the court, sit here and say no one should worry about that. I'm worried about it. Anyone should be worried about it. But I think, in using the rubric, using the rule that Ms. Sargent just referred to, there is simply no, actual evidence. There is simply no evidence contradicting these conclusions that the hearing committee came to, I think based on the examination of a lot of factors, this is not just Mr. Libertelli's word. This is reflective of diagnostic information that the hearing committee was exposed to from a whole host of people, Ratner, Sugarman, Labby, Kirsch, et cetera, et cetera. So all that evidence, this is evidence from a lot of experts, who were not brought to bear at the time that Mr. Libertelli was engaged in this conduct in Montgomery County before Judge Storm. But there's simply every reason to believe that there's been this kind of cessation of drug use that I just referred to in those two findings of fact, and no reason other than concern, absolutely rational and understandable concern, but no actual evidence, no evidentiary reason to disbelieve that those substances were no longer used as of that time. And then I guess my question is, how could that not be recovery within the rubric that Ms. Sargent referred to? And I believe Mr. Hora has a hand up.
I think actually Ms. Pittman has had her hand up for a while.
Forgive me, I didn't see it.
And then let's go Mr. Hora. I've got a question after that. But
I actually want to walk away from rehabilitation for a moment, because I do know that you had two causation issues, but I guess if we have more on rehabilitation, I'm going to let my colleagues.
Mine is about rehabilitation, actually. Yeah. Because I just wanted to make sure I understand, because you're not contesting any of the findings of fact by the hearing committee. And in 251, it says, but he seems to have bought cocaine as late of December 2020. And at other points he testified in the disciplinary hearing, he is on a slowdown that continues until the present day. So how does that, I guess that's different than what you were sort of testifying.
Well, I'm sorry, I didn't mean to interrupt. Go ahead.
Yeah, I think that is different than what you said, that there's no evidence that we could point to that he continues to use after December 2020. So I just wanted clarification on that point.
Very much appreciated. And I actually should say, we do contest factual conclusions, not so much, kind of the ones that are in the weeds, but the overall conclusions, with respect to causation and recovery, which are mixed questions of law and fact. I think we do actively contest those, mean to contest them. And I should say also, I also took careful note of that, though there are a couple of different observations that the hearing committee makes about that. And Ms. Porter refers to them in her brief as well, this idea that he's on a slowdown. It's worth actually looking at the pages of the transcript, because I think what's referred to there, I think this is purely Mr. Libertelli's testimony. And if I remember correctly, there are two transcript excerpts that are invoked with respect to that observation. I read them in preparation for this argument carefully, and I don't think either one of them it reflects Mr. Libertelli saying, I'm still using, but occasionally, or something like that. I don't think that's what he's saying at all in those excerpts. So to the extent the hearing committee is, I don't think they're saying it, but to the extent they're suggesting that that's what's actually going on, and that there is, evidence, let's say even from Mr. Libertelli, that he continued to use cocaine after December 2020, I don't see that in the record. And we do actively contest the proposition that the record would show that. I don't think it does. I think all the evidence is is what the hearing committee said, that he stopped at the end of 2020, obviously an enormous struggle, obviously an enormous amount of dishonesty prior to that time, but no evidence whatsoever that he's ever utilized that substance since the end of 2020. I think somebody else.
Ms. Pittman had a question.
Yeah, so I'm going to jump in because I do want to make sure, because you raised two causation issues. We talked about the causation for the opioids and the cocaine. I want to get to the more generic causation of substance abuses generally causing this particular misconduct. And for that, I do see that you cite to, for example, Dr. Ratner, who says there's a strong connection between substance abuse and the behavior in the divorce proceedings. And I think it's fair to say all of the behavior is going to be largely dishonesty to hide the drug use through the drug test, to include the funds used to pay the drug dealers. What I'm asking you, I think, is a couple things. If you can give me sort of your best record cites of the support that it is the substance abuse that caused the dishonesty. And I'm going to be kind of upfront about where my concern is, because I think that will help you in responding. It feels rather circular to say the substance abuse caused the dishonesty because we see substance abusers frequently being dishonest about using substances. It reminds me of like someone who commits theft tends to lie about committing theft. And just because criminals lie, we don't then say they have a disability and that causes it. And so if you can give me sort of the best record site for the doctors explaining why they think the dishonesty comes from the substance abuse disorders. And it might also be helpful if you can point to any other areas where he was dishonest, if there is, and there may not be. That was a long question, but
I don't know. It's very much appreciated. Actually, that's probably the single most important. The thing I was most focused on in preparation for this proceeding was exactly the question you just posed. I think that what you just said captures perfectly like the sort of the fundamental problem that I perceive, that we perceive in the hearing committee's conclusions. And I think, and I'm sort of reluctant to characterize it this way because, the members of the hearing committee, who obviously we spent a week with, these are just extraordinarily able lawyers and just really extraordinarily sophisticated in their thinking. But, I think what afflicted them is something that afflicts all of us. And I include myself here. We talk about addiction as being an illness, but I mean, how many of us really believe that? I mean, how many of us really, really believe that it's just an illness as opposed to something that should be looked at, morally or moralistically, at least in some component? I think many of us still have that thinking back there. And I think that sort of afflicted the hearing committee in terms of their evaluation. And I think it's precisely that distinction, Ms. Pittman, that you drew between a thief who's going to lie about thieving or stealing because they don't want to get caught versus what happened to Mr. Libertelli. That's the distinction. That's probably the single most important distinction in this case, to my mind. And the distinction is expressed by Dr. Ratner, particularly by Dr. Ratner, and I do have those record sites, and I'm going to quickly run through them if I may. But I think Ratner articulated them particularly well because somebody who steals, this does not afflict their judgment. And I'm not suggesting for 1 minute, that Mr. Libertelli was high, when he was the whole time when he was making these adjustments to these documents, or, that he doesn't know the difference between right or wrong, or that he's incompetent. Those kinds of suggestions are just off the table from our standpoint. They're preposterous on this record. I would never say a thing like that. I think it'd be baseless. But yes.
Could you run through the record sites now?
I will.
Your rhetorical argument is very clear. But
appreciate it. So,
what's
absolutely.
your record sites? Like Ms. Pittman asked for your best record sites.
So finding of fact 223, they say Ratner's testimony is fair and even-handed, and they point out, and this is important to me, they point out that Dr. Sugarman does not dispute Dr. Ratner's basic conclusion that some part of the drug use affected Libertelli's judgment and made him less cognizant of his likelihood of getting away with it. But I don't think that's all it is, basically. That's judgment, but that's just one part of the judgment issue, and they point out that the conclusion seems reasonable. They cite DCX 49 and 67 and transcript 1352 of the page 1352 of the transcript, which I think is part of Dr. Sugarman's testimony. And then let's see, Sugarman says, quote, and this is at that same place, I think it's transcript 1352. He says, Libertelli's judgment, quote, was more likely than not partially compromised by his substance abuse. And this enjoys a substantial additional support. First, Dr. Wood, whose testimony we don't have in the record, but it is referenced in DCX 49 at page 44, where it says Libertelli exhibits defects of insight, self-awareness, self-control, and judgment commonly seen in individuals with a history of chronic, heavy use of psychoactive substances, and displays a diminished capacity to appreciate important risks associated with the use of opioids and cocaine. And this is most important, a lack of insight into the effects of his use. And then we we have Judge Storm, who quotes Dr. Teeter. And I thought this was particularly important, and disciplinary counsel didn't, I thought quite properly, didn't dispute it, where Judge Storm, who presided over quite a number of hearings relating to Mr. Libertelli, talks about Teeter's conclusions about how addiction hijacks, here I'm quoting, hijacks normal thoughts. That appears to be, Judge Storm says, what happened here, the hijacking of a good person, worked hard, phenomenally successful professionally and financially, father to beautiful children, whose normal thoughts and normal thinking was hijacked.
Mr. Coburn, first off, thank you for all those cites to the record. But for me, it begged this question. You seem to be supporting that respondent has been substantially rehabilitated because he has ceased his use of opioids or other addictive substances like cocaine. It seems, given what you were reading to me, that in order to see some substantial rehabilitation, to address what you said, lack of self-awareness, lack of judgment, those sorts of other parts of this type of disease, we're not getting those unless you could point us to factors that support that part of a rehabilitation. What I'm hearing you say is your factor to show he's substantially rehabilitated is that he's no longer using. And it seems from the record that may be the end of the rehabilitation. But given what you just read, it seems like we would see some additional steps towards rehabilitation, like the disciplinary counsel noted, continuing to stay with an addiction counselor, having some sort of addiction sponsor to help through this process. So can you comment on an additional steps that show he's substantially rehabilitated other than the stopping of the use? Thanks.
Ideally, relatively quickly, then we'll hear from disciplinary counsel and come back.
Oh, absolutely. I'll make it quick, Mr. Chair. And, there are a couple, I think it's actually two questions. There are a couple of things here. One is there is testimony from Dr. Ratner going specifically to that issue, to the effect of, and I'm forgetting exactly, the subjunctive methodology he uses, but he says something to the effect of he would never do it again, or he would never do it now, or he would never have done it. He would never have had this kind of lapse of judgment, but for the substance abuse. Ratner has testimony in the record to that effect. I don't have the page here, and I apologize for that. But there's also material in his report going specifically to that. And I'm just struggling to remember the second part of what you said, which is it goes to the question of recovery. I remember. So this is a problem that we grappled with during the course of the hearing, because I know that there is this kind of notion that wouldn't it be better if Mr. Libertelli, had like a certified sponsor, or if he went to NA every week or something like that, and he doesn't do that, and he doesn't have that person. And that's something where I would commend to the board's attention Dr. Kirsch's testimony. I think I said something in our opening brief to the effect that it would be worth reading that testimony from cover to cover. Kirsch is sort of really kind of poetic on this subject, in my view. He knows Libertelli, I think, better than anybody else who testified in this proceeding. And he talks about how, substance abuse recovery is different for everybody. And what Libertelli is doing, his particular approach to it works for him, as opposed to a different approach, like we'd have a full-time, sort of like a regularized counselor relationship, with a sponsor that might work better for somebody else. But I think Kirsch answers that question.
Thank you. All right, Ms. Porter, you've got 20 minutes. Thank you very much, Mr. Coburn. If I could ask you to mute yourself, just,
Certainly.
I see the clock is set. Ms. Porter, whenever you're ready.
Okay, thank you. I want to start out with the nature of Mr. Libertelli's misconduct. I think there is no dispute, and the hearing committee found it was extreme and flagrant. And I think it's also important on the Kersey issue. I think, as Mr. Coburn admitted or acknowledged, this was not a spur of the moment misconduct, and it was definitely not isolated. Mr. Libertelli meticulously altered and fabricated 67 drug test results, and he did it over an extended period of time on a weekly and sometimes more than once a week. That was not all. He falsified scores of financial records for multiple accounts. And as the hearing committee found, those two were skillfully executed and very calculated. Mr. Libertelli lied under oath numerous times, and he lied when he was not under oath. And that dishonesty too was deliberate and calculated and meant to support and did support the false evidence that he was producing. Contrary to Mr. Libertelli's claim at the hearing, he never made a voluntary disclosure of any of his misconduct during the Maryland court proceedings. To the contrary, to the extent that Mr. Libertelli ever admitted misconduct, it was only after the opposing side obtained evidence through either his financial institutions or the drug testing facilities and presented it that Mr. Libertelli admitted the misconduct.
So Ms. Porter, I'm going to interrupt there. We're familiar with a lot of cases that result in, I shouldn't say a lot, but there's cases that have Kersey mitigation where the facts are terrible. I think Kersey and there's a few others where the court and the board explicitly states that the behavior is inexcusable, but nonetheless, if the three prongs of Kersey mitigation are established, that we do not then punish that attorney for a disability. And so my question for you is sort of the flip of what I was asking Mr. Coburn, which is that here you've got evidence that judgment is affected by these substance abuse disorders. And I don't think that I mean, correct me if I'm wrong, but I don't think that judgment is going to be affected only for one day. It's going to be affected for the entire time that you have a substance abuse disorder and you're using. And so you're going to have multiple instances of it. And so could you give me sort of what you consider to be kind of your best response to why the evidence here doesn't show appropriate causation for the substance abuse disorder when you've got all these doctors explaining that it does reflect bad judgment?
Sure. Let me just start with, I guess, maybe correcting the premise that there are a lot of cases dealing with awful misconduct. None involving the calculated and deliberate falsification of documents on such a scale as here and over such an extended period of time. So I would take issue with that. And as for the causation, first, I note that it was the opioid use disorder that Mr. Libertelli and his counsel were relying on for Kersey mitigation. In showing causation, and rehabilitation, which doesn't even come into play unless you can show causation, one of the things that you look at is whether the removal of that opioid use disorder stopped the misconduct. Well, as the hearing committee found, Mr. Libertelli continued to lie repeatedly to the court and engaged in perjury at almost a year after he'd stopped using opioids. That is one factor that cuts against the causation. And the Lopes case, I think, is instructive. Lopes had a number of problems, and the court had depression, and he was taking medication that had quite an adverse effect on him. And so the hearing committee found that because of those physical and emotional problems, there was a disability, but there was no causal link between that and the dishonesty, because those were intentional, deliberate actions, and the disability or the impairment that Mr. Lopes suffered didn't interfere or prevent him from understanding the wrongful nature of the conduct, from weighing the costs and benefits and appreciating it. And that is also what the hearing committee found. Certainly, the use of drugs may affect judgment, and it may affect someone, significantly, but there was no evidence that Mr. Libertelli was ever under the influence of drugs when he was doing all this misconduct, that he wasn't able to fully appreciate what he was doing and what he was doing was wrong, that he didn't weigh the cost and benefits, and that he knew that this was conduct that could get him disbarred. There's no evidence that any of that, that he was deprived of that ability to understand. The fact that it continued long after Mr. Libertelli stopped using opioids was another factor that the hearing committee rightly and understandably found was significant in finding a lack of causation. The other thing I'd note is, unlike some of the other cases that have gone through the system, when there is a substantial impairment, when there is a disability, you see it in not necessarily every, but many aspects of the lawyer's life. That was certainly true in Kersey. It was certainly true in Rich, a recent case that this board sat on. It was true in other cases where you see that Mr. Rich wasn't coming into the office, his relationship with his wife, his relationship with his family, others. You would see it across the board. Here, there is no such evidence. Indeed, the colleagues and friends whom Mr. Libertelli called as witnesses had no inkling that he was even taking drugs, and testified as to the sophisticated work he was doing in high-powered jobs for which he was being paid $1 million during the time he was engaging in this misconduct. So it's an odd situation where you claim that you're substantially, or this substantially affects you, but it only affects you in this one small category of conduct, and that is misleading and filing false evidence and lying to the court. Another issue, I mean, that is another factor, I think, that cuts substantially in favor of the hearing committee's finding that Mr. Libertelli did not prove that there's a causal relationship. And the hearing committee—
Ms. Porter, just to clarify, because I think this is what you're saying, and maybe this is not important, but I read your brief as taking issue with prong 1, clear and convincing evidence that respondent had a disability or addiction. Now, are you I want to give you the chance to articulate,
Sure.
Not just on the papers. Are you saying that opioid use you're not saying opioid use disorder is not a disability?
Well, I think it's a little bit more nuanced than that. I think, well, the board in the Schumann case, said, and I recognize that the court didn't reach the issue, but the board in the Schumann case said a diagnosis is in itself is not enough to satisfy the first Kersey prong, excuse me. And I think if you look at the Lopes case, I think that actually is consistent with and supports what the board found in Schumann, and that is having a opioid use disorder. Certainly it's a disorder, it's recognized, but that doesn't necessarily mean that it's a disability or substantially impairs the lawyer and the lawyer's ability to conform his conduct to the ethical rules. And that's in fact what the court in Lopes, that's the analysis of the court. They said, well, we're going to look at his depression, Mr. Lopes's depression, and we're going to look at the fact that he's having all these reactions to the drugs he's taking and the extreme fatigue and these other symptoms that he described. And we're going to find that because it prevented him from going into the office, from returning calls, from whatever else, it does qualify as a disability. And then they went on to the causation issue and said, okay, we look at this disability and we say, okay, there's a causal connection, or we can see that it substantially affected Mr. Lopes' conduct when it came to the neglect violations, because, you can see how someone who couldn't get out of bed, who, had extreme fatigue, couldn't attend to, his obligations to clients and to the court. But the court said, but we don't find, or we agree with the board, that there isn't that causal link when it came to Mr. Lopes's dishonesty, because notwithstanding they had this disability, there is no, kind of causal link. So I know that the two concepts of, is it a disability and is there a causal link, they're intertwined, and you look at a lot of the same facts or the circumstances, but disciplinary counsel, I guess, supports what the board found in Schulman, and I think as I think is supported in the court's reasoning in Lopes, that just diagnosing someone with an addiction or mental health illness doesn't get you all the way there, because you have to look at the degree of impairment. And that goes back to my answer to Ms. Pitten's question about this degree of impairment. Sure, I mean, people take drugs because they do have an effect. The question is how much did it affect him? And
But then why, and maybe I'm just being overly formalistic about it, but I think it could be important in the future. Why isn't everything that you're saying wrapped up in prong 2, which is causation?
well, I think there is a lot of overlap. But I wouldn't concede the issue, or I wouldn't agree that having a diagnosis of opioid use disorder will always be enough to satisfy the first prong. And I think all of the experts who testified say it's very individualistic. And I think most of them too, well, I think as the hearing committee, I guess, found, if he was substantially impaired, or if he was really disabled, or this really impaired him, you'd expect to see it in other aspects of his life. His work and his work history alone, I think, should give the board pause, as it did the hearing committee. Mr. Hoare, I saw you. I'm sorry.
Yep. My question is, to what extent is the ability to continue to use the, in this case, opioids or cocaine or whatever it might be, the ability to continue to use the drugs is the motivation for the misconduct? Because to me, that's what I see here, where he is, the respondent is engaging in misconduct in order to enable or allow him to continue to use drugs while still allow him to have access to his children and so forth. And the inability to give up the drugs in order to be able to see his children was causing the misconduct. I mean, does that at all play into your analysis as to whether or not the impairment itself, the need to have the drugs and the ability to continue to use drugs, is causing the misconduct at issue?
I don't, well, if I understand your question correctly, I think that, hiding his drug use, or maybe being able to continue to use the drugs, was one of the reasons, or maybe a motivation for falsifying all these records. Although, as a hearing committee found, the financial records were falsified for other reasons. But I don't think it satisfies that substantial cause factor under the case law, which is basically, as the Lopes court, I think, said, it basically deprived him of a meaningful ability to comport himself in his professional conduct in accordance with the basic norms of professional responsibility. And there's no evidence that Mr. Libertelli's drug use did that. And indeed, the fact that when he stopped using the opioids and continued to lie, that again undercuts, or substantially undercuts, any causal link between his opioid use disorder and the misconduct, which continued again afterwards.
I'm sorry, continue.
I was just going to say, one of the other factors, and I know we discussed this in our brief, is that all the drugs that Mr. Libertelli was using long before the misconduct occurred were all illegally obtained. And as the hearing committee found, there is no connection, or Mr. at least Libertelli didn't make the connection between his opioid use disorder and his cocaine use, or cocaine use disorder. Indeed, the hearing committee found that his cocaine use started before he started using opioids. It continued while he was using opioids, maybe increased, but it continued after he stopped using opioids. And there was nothing to indicate that while he may need a stimulant, it had to be cocaine. And there's no evidence, including from Dr. Ratner, to the
Can you actually address that issue? I'm sorry to interrupt, Ms. Pittman, if you, I know you're going to ask a question, but along those lines, can you address why is it that we should maintain a rule or a rationale that only allows for Kersey mitigation with respect to legally obtained drugs versus non or illegal drugs like cocaine, et cetera? Why does that rationale help our profession versus having a situation where only illegal drugs are at issue and someone comes out through the end of it and is able to rehabilitate themselves? Why can't they return to the profession because their choice of drug was illegal versus legal?
Okay. Well, I first start off with just a statement that Mr. Libertelli and no other lawyer is being punished because they, in this case, because they used illegal drugs. What they're asking for is that, notwithstanding the extreme and flagrant dishonesty and fraud that went on for 3 years, I should get special treatment or my sanction should be mitigated because I engaged in criminal conduct and used illegal drugs. I think the court in Marshall addressed the reason why we don't want to go there. I mean, there's many purposes or policies behind attorney discipline, including deterrence and also maintaining the integrity of the bar. And as I think the court stated in Marshall, to tell the public, to tell other lawyers that you can engage in illegal conduct for which, people can be criminally prosecuted and go to jail. And that should somehow be a mitigating factor for an officer of the court, particularly one who's engaged in such extensive conduct, sends the very wrong message to the bar, to the court, and to the public.
But going back to Mr. Coburn's point, isn't that part of why we are distinguishing drug use as potentially, or addiction to drugs as a disease versus, let's say, criminal conduct of theft or sexual misconduct, rape, etc. There has to be a distinction, right, between drug use and addiction and some of these other criminal behaviors. And really, I guess I don't know if your analysis of Marshall pertains to our present day, whether or not that really addresses the distinction between drug use and addiction versus, let's say, your other sort of crimes that might disqualify you to be a lawyer.
Well, I think Marshall does address the drug use when it comes to cocaine, that, your first use of the drug is itself an illegal act. And that was true in Mr. Libertelli's case. He started to use cocaine before he used opioids. But even the opioids, if you go back and look at the evidence, and I know that Mr. Libertelli's testimony and evidence about this kind of changed with each telling, but the evidence of this record shows that he had a legal prescription for opioids when he was 13 or 14 years old. And then he had another one from Dr. Aguilar in 2009 or 2010. And Dr. Aguilar testified that that was for a 1 week prescription. There was no evidence, in fact, Mr. Libertelli's testimonies to the contrary, that he was addicted to opioids after taking that 1 week script. And there was no testimony from a doctor that he was addicted. But by 2011, he was buying illegal opioids, and he continued to do so through 2015. Now, he did have a few other prescriptions during that time, but there's no indication, around the times of his surgery. So again, even in the Marshall analysis, when he started buying illegal opioids, there's no testimony or evidence, and the hearing committee did not find that he was addicted to opioids. So again, it's kind of the voluntary, engaging in criminal conduct that the disciplinary system should not, recognize as a mitigating factor when a lawyer, like every other citizen, has an obligation to obey the criminal laws, and it should not be a basis to mitigate.
So is your argument that to apply Marshall in the opioid context, the respondents got to show that the addiction started during the time there was a lawful prescription? That's a little fine, right? I mean, the opioid crisis is like a big bad thing.
No, I know, but I'm basically, what I'm trying to say is that their premise that he was addicted to opioids before he voluntarily went out and bought illegal opioids is not supported by the record evidence.
But in order to fall within the present, in sort of the present or the current rubric, you have to make that argument, right? That's what the respondent is being forced to do under Marshall, is to make that argument, whether or not it's true or not, and to try and find a way to sort of. The fact of the matter is, if the respondent never had a legal prescription for opioids, he wouldn't even be here today, right? We wouldn't even be having this argument because he never would have qualified for Kersey mitigation to begin with.
I don't know the answer to that, because they're also arguing, even though they didn't raise their acknowledgement form, they're also asking you to consider his cocaine, or his addiction to cocaine, which Marshall clearly says was not a basis to mitigate. And the hearing committee found there was really no causal link between, or, that he used cocaine or he had to use cocaine because he was using opioids, or that it too, even in combination with the opioids, caused him to engage in the misconduct. And if I could just briefly, I know my time is up, but I want to just address the rehabilitation, just because I know that that was an issue that you explored with
Please.
Mr. Coburn. First, it doesn't even come into play unless Mr., if Mr. Libertelli is not satisfied the first and second prong of Kersey, which we submit he is not. But the hearing committee's discussion of the rehabilitation and the facts that they found to find that he hadn't proven rehabilitation, even by a preponderance of the evidence, much less clear and convincing, is supported by all the record evidence, including the fact that when he stopped using opioids, Mr. Libertelli continued to lie. And indeed, he continued to use illegal drugs after he was reported to disciplinary counsel, after disciplinary counsel filed charges against him, and even into 2021. As far as the therapy, I think it's noteworthy that Mr. Libertelli was involved in intensive outpatient therapy, followed by 2 years of therapy. The entire time, well, not the entire time, but most of the time, he was engaged in this misconduct. And I think the report of Mr. Labby is very instructive. And as the hearing committee found, even though Mr. Libertelli began therapy with Mr. Kirsch sometime in December of 2020, just 6 months before the hearing, Mr. Libertelli has not been forthcoming with his Dr. Kirsch, with his own, internist, Dr. Agrawal, or even Dr. Ratner. Dr. Agrawal knew little, didn't even know about his opioid use until after he was reported to disciplinary counsel, and knew virtually nothing about his use of other drugs or his misconduct. The same is true of Dr. Kirsch, that he knew little about his other drug use, and even with respect to Ratner, although not a treating doctor, but an expert, he was provided incomplete and misleading information about Mr. Libertelli's drug use. I think the other thing that the hearing committee talked about, which I commend to you, is that not only did Mr. Libertelli lie long after he stopped using, but he continues to deflect blame and lash out at others. That includes his ex-wife, Yuki Noguchi. It includes Sophie Chen. It includes the court supervisor. It includes Dr. Labby after he issued his report. This was all conduct that occurred long after Mr. Libertelli stopped using drugs. And finally, the whole notion that this was to, somehow protect his access to the children or his two sons is, as the committee found, objectively false. What he did had nothing, not only it was to hide his drug use and also to hide his financial dealings, but he always had access to his children. He chose not to see them. And that was evident from the hearing and his testimony and the testimony of others, and is found by the hearing committee. In short, this was flagrant, extreme, and extended misconduct. Anything less than disbarment would disserve the purposes of attorney discipline.
Okay, thank you. Mr. Coburn, you have 5 minutes. As soon as it's on the clock, take it away. Thanks.
Thank you, Mr. Chair. I think I have a real fundamental disagreement with disciplinary counsel about the last thing that Ms. Porter said about the proposition that appropriately crediting the impact of the use disorders here, both opioid and cocaine. And I think that, like I said earlier, the testimony, the unrefuted, unrebutted testimony is that one led directly to the other. That, that crediting that using that as an appropriate factor, mitigating factor, would disserve the purposes of attorney discipline. I think that proposition, and I think, the proposition, of course, Mr. Hora picked up on in terms of what we're urging should ultimately be adopted, which is essentially former Chief Judge Wagner's dissent in Marshall. We just think she was absolutely correct about what she said there, that this should be a, kind of a sensitive, careful judgment based on all the factors and shouldn't be as mechanical as it currently is under Kersey. I think that's directly consistent with the objectives of attorney discipline. I think that's what attorney discipline is all about. I think attorney discipline needs to take account of all the relevant factors. It's perfectly okay with me. I mean, Dr. Ratner found that, our client was not without personality issues. And certainly some of those personality issues have caused him to lash out at certain points. And, Dr. Ratner sought to explain that in terms of why. There's a lot of information in Ratner's report about, Mr. Libertelli's dad and those kinds of causal factors and so on. All that factors in, all of it's relevant, all of it factors. But, from our point of view, this is just sort of too mechanical and not even consistent with the rubric as it exists today to say that, Mr. Libertelli, had to not be able to appreciate the wrongfulness of his conduct, or he had to be impaired in every area of his life, which in point of fact, there's evidence in the record that he was. I mean, there's evidence in the record that Ms. Noguchi said that, was her understanding that was because of his substance abuse that he got fired from Netflix, if I remember correctly, and or Skype before that. And, it's like, but the thing to focus on here from our point of view is that, disciplinary counsel says that it's got nothing to do with his kids. But the evidence in this case, and this is not just from Ratner, but it's also from Sugarman and Labby and Kirsch, is that this had everything to do with his kids. He was attempting not to have his ability to visit his kids revoked in Montgomery County. And that's what this was all about. That's what he was terrified of. He wasn't terrified of failing at work. I mean, it didn't have anything like that kind of emotional component such that it would, kind of affect judgment in the way that it affected judgment here. He is, and this is, I think all the expert testimony in this case is that he is focused above everything else on his kids, focused on his kids. And, and he's terrified, lives in terror, certainly did at the time of his access to his kids being revoked or circumscribed. And that terror was, that interplay between that terror and the adverse effect on his judgment that is testified about not just by Ratner, but also Sugarman and the other experts I referred to. That's what led to this. We are not seeking to exculpate him at all. We're not saying that that's an excuse. We're not saying that that means he gets to go back to the active practice of law. We're not saying anything like that. We're saying that it's substantially mitigative, that the opioid use disorder, which led, I think, through irrefutable testimony or unrebutted testimony, I should say, in this case, to the cocaine use disorder. I mean, I think it demonstrates that Mr. Libertelli's addictions are substantially mitigative. And certainly it's true that he kept lying, after early 2018. But I mean, he'd already been lying to that point. I mean, does that somehow sever the causation argument at that point? I mean, I just don't think it makes any sense. And I seem to remember Dr. Ratner referred to that as well. So I don't want to repeat myself, and I kind of sense that I may be doing that. I think that the evidence here is substantially mitigated, and that for justice to be done, that mitigation needs to be given effect.
All right.
With 30 seconds left, that's all I have.
Thank you very much, Mr. Coburn. Thank you very much, Ms. Porter. The case is submitted. Take care.
Thank you so much.